Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. If you are a person who has assets before you get married, you've got to wonder whether or not, once you get married, what's the status of those assets? You know, nowadays, people seem to get married later and later. My folks got married when they were 22. When I think of a 22-year-old now, I think of somebody that's barely out of high school. Certainly not the maturity to get married. I mean, that's my perception of it. That seems awful young, but at the time, that was how it was. Nowadays, I think people are, as they educate themselves, they get further on in their careers, I think people are marrying later. And because they're marrying later, they might have assets. They might have had time to accumulate assets that a 22-year-old doesn't have time to accumulate. So they may come into the marriage with their own house, with their own stuff, with their own cars, this, that. So if you come into the marriage with a house that you bought before the marriage, it may be before the marriage, but it may be before you started even dating this particular person, before you even had any kind of notion that you were going to have life with them. Is that place at risk in a subsequent divorce? Might you lose that house in a divorce? Well, I will tell you this. The quick answer to the question is, if it's prior acquired property that you keep separate, it's separate asset. It's yours. It's not a joint marital asset. It's a separate individual asset, and it's yours. And you don't have to worry that you're going to lose it in the divorce. That's the simple answer. But that answer presupposes certain things, and that's what this discussion is really about. If you, for example, have a house, and it's in your name, and it's yours, and you've had it for years and years and years, and then you meet someone, and you start dating, and you get married. As long as you keep that house in your name, there's no indication at all that there was any effort being made to somehow gift that house to the marriage, gift that house to the other person. However, if you get married and you decide, here's something cute, I think I'll change the deed from me to me and my wife. Yeah, great idea. Well, you know what you've done? You've not only made a transfer of real estate when you hand over that deed, but what you've done is you've essentially gifted the house to the marriage from a single property to sort of a joint thing, which is all good and well, unless you get divorced. Now, what you've done is you've created a joint asset subject to division. If it was worth $100,000, now 50 of it is yours and 50 of it is hers. In doing this, what you've really done, see, before you did this, that whole $100,000 was yours. Now you've split it. Now, even if you don't do that, of course, there can be an argument about whether or not a separate property that grows during the marriage is the equity, something subject to division. It may very well be, depending on certain circumstances. But the corpus of the house is separate unless you do something to change that. So there are many things that you can do. You can deed it. You can, for example, if you're filing joint tax returns, there are certain things that can be done where the court might say, well, gee, you're really using this house as a joint thing during the marriage. You're using tax advantages on this property on your joint return. You're doing some things that make it look like you're kind of commingling the benefits of it. And I suppose one must watch out for that in order to avoid that kind of thing. However, I will tell you that generally speaking, you have the house, it's in your name, you keep it in your name, you keep it separate, you don't in any way commingle the house or its value with the marriage. If you do it that way, it is much less likely that you run into a situation where you have to lose your prior acquired home. Now, if you have any questions about your particular case, of course, reach out and we'll be glad to help you out.